Welcome to S&C's Critical Insights. I'm Annie Ostrager, a partner in the firm's litigation group and one of the co-heads of our employment law group. Joining me today is Kamil Shields, a partner in our litigation group, a member of the firm's criminal defense and investigations group, and a former prosecutor.
Hi, Annie. As always, it is wonderful to be with you and Sabrina today.
Yes, great to be back with you to wrap up our series on whistleblowing. And yes, Sabrina Solow, an associate in our litigation group, is also back to continue to moderate our series. In our previous episode, Kamil and Mehdi Ansari, the co-head of our intellectual property group and the artificial intelligence practice, discussed recent events at the intersection of AI and whistleblowing. If you missed that episode or any of our prior episodes in this series, you can find them in the S&C Critical Insights library. Today, we're going to wrap up our series and we'll underscore some key takeaways and themes for our listeners and talk about areas of whistleblowing law that we're monitoring and where we expect to see some continued activity. So with that, I'll turn it over to you, Sabrina, to get us going.
Thanks so much, Annie, and it's great to be back with you both today. In our first 4 episodes, we discussed a number of whistleblower regimes, including DOJ and SEC programs, and relatively new programs put in place by DOJ Antitrust Division and FinCEN. We also addressed the role of qui tam actions under the False Claims Act and proposed legislation seeking to protect whistleblowers in the rapidly moving AI space. Kamil, do you want to give us high-level some key takeaways from this series?
Definitely. Thanks, Sabrina. And I think I'll start with 2 points that, in my view, are worth reiterating. First, as we've discussed throughout this series, there are a wide variety of whistleblower regimes that incentivize whistleblowers. And these programs really do have the potential to allow whistleblowers to recover a great deal of money. Some of these programs are quite well established. You mentioned, for instance, the SEC's program. Others have been created in the past couple of years, like the DOJ Corporate Pilot Program that I think Annie and our partner Nick Borton discussed. And then there's the Anti-Divisions Program, which Kyle and I discussed, which is quite new. The increase in the number of these programs is definitely a trend that, in our view, bears watching. As we've discussed throughout, these programs generally require original information that is voluntarily provided. And what that means in terms of original information and whether or not it's voluntarily provided is something that changes across the various programs, but those requirements are in place that it be original and voluntary, even if the definitions may differ across the programs. And because these whistleblower programs continue to proliferate while shifting slightly in terms of the incentives offered and the nature of that voluntary information is provided, it's imperative in our view for companies to have a strong compliance program, and that really allows them to maintain a wide view in terms of the whistleblowing landscape. Second, we've seen at a high level that the government's reliance upon whistleblowing programs to target potential misconduct truly is increasing. As Mehdi and I recently discussed in episode 4, as Annie stated at the outset, there's been bipartisan momentum behind the protection of AI whistleblowers. And those whistleblowers may not be protected by existing whistleblower legislation and whistleblower programs because the AI space is so new. And some of the misconduct that's described in this bipartisan legislation that is seen in the space might not actually be illegal.
I agree. And we are, as you said, Kamil, seeing some shifts in substantive priorities. For example, as we discussed in episode 1, during the Biden administration, there was a big push from the SEC to bring enforcement actions under their Rule 21F17, which provides that no person may take any action to impede an individual from communicating directly with the SEC about a possible securities law violation, including enforcing or threatening to enforce a confidentiality agreement that would have that effect. And as previously discussed, the SEC has sought to apply that rule to a wide variety of clauses in common employment agreements, including any type of settlement agreement, severance agreement, a policy that includes confidentiality or non-disparagement language, also to representations in agreements where employees say that they have not previously filed any complaints with a government agency, to language in releases and beyond, taking a very broad interpretation of the rule. We are not, however, seeing the rule used in that way in the current administration. We're also seeing some potential procedural differences as well. For example, in our first episode, we described the Trump administration's submission-focused interpretation of the original source rule, as opposed to the Biden administration's information-focused approach. And of course, in episode 3, we highlighted changes to DOJ's corporate pilot program to align with certain administration priorities, including tariffs, immigration, sanctions, and national security.
Thank you both. We also discussed a recent dismissal of a decade-old pending key TAM action, United States on behalf of Vermont National Telephone Co. v. North Star Wireless LLC. And more broadly, we've been seeing some interesting whistleblower-related cases make their way into the courts. For instance, in our intro episode, we referenced a case in the Third Circuit, Doe v. SEC, in which 2 whistleblowers came forward with information to the SEC, but only one earned an award and the other was denied, and how the difference there hinged on the SEC's interpretation of the original source rule. We also discussed in some detail in episode 3 another pending Third Circuit case, United States on behalf of Solow v. Janssen Products, this time involving a constitutional challenge to the key TAM mechanism under the False Claims Act. And we'll be back to discuss further developments when Solow is decided. In the meantime, let's discuss what else could be coming down the pike. What are trends you're anticipating or areas you're watching in the whistleblowing space?
I'll start. So one significant area of focus where we're already seeing activity, including based on whistleblower tips, is investigations of federal contractors. Earlier this year, the administration announced its Civil Rights Fraud Initiative, the purpose of which is to investigate and, as appropriate, pursue claims against any recipient of federal funds that knowingly violates federal civil rights laws. The initiative is intended to enforce policies announced in various recent executive orders aimed at certain forms of discrimination. These executive orders include 14151, which requires the termination of all discriminatory programs, including illegal DEI, and Executive Order 14173, which signals the administration's intention to use the False Claims Act to target DEI programs that it views as being in violation of civil rights laws through a provision that mandates that recipients of federal funds certify that they are not operating any programs that promote DEI that violate any federal anti-discrimination laws. Although the latter order remains in effect, it's currently facing constitutional challenges in a case pending in the Seventh Circuit.
Thanks, Annie. And we expect that universities could be a particular area of focus as the basis of a False Claims Act action. And that action could be pursued on the ground that the university is violating the DEI policies that you just discussed in these executive orders. While we have not yet seen, there hasn't been a public announcement of a False Claim Act enforcement action brought against a university by the Civil Rights Fraud Initiative. According to news reports, investigations by the DOJ have started based on this theory. So we haven't yet heard of an actual enforcement action, but given some of the press attention here, we have heard these are theories that DOJ is pursuing with respect to the False Claims Act.
Why do you think the FCA is being invoked here?
Well, the FCA offers powerful remedies to recover losses sustained as a result of fraud against the government. The government can recover treble damages for each false claim. In cases brought under the theory that the defendant made a false representation of compliance with civil rights laws, which would include but not be limited to Title VI, which Kamil was just discussing and is relevant in the university context, and Title IX, certain courts have adopted the view that the measure of the government's damages under the False Claims Act would be the amount that it paid out by reason of the false statements over and above what it would have paid if the claims had been truthful. So a False Claims Act action could enable the government to recover 3 times the amount of grant money it provided, for example, to a university.
And Annie, while we're discussing obviously the new civil rights fraud initiative, the use of the False Claims Act by DOJ, as we have discussed previously, is not new. In recent years, DOJ has used the False Claims Act to secure settlements of up to $112.5 million with various higher education institutions. And some of those reasons, the basis for the enforcement actions include failure to disclose that professors working on grant-funded projects had affiliations with foreign governments, improper use of federal grant monies, and submissions that contain falsified research. So it's that financial exposure that you've previously mentioned that makes the False Claims Act such a powerful tool. And it appears that that financial exposure is also a way that DOJ appears willing to have leverage to compel significant policy changes.
Yes, I agree. That's certainly correct, Kamil. And to return, Sabrina, to the question you posed on why the False Claims Act is being invoked here, the False Claims Act also enables private whistleblowers, as we've discussed throughout this series, which in this context could include students, employees, or advocacy groups to file suit in the name of the government. And DOJ's messaging here has been that it strongly encourages anyone with knowledge of discrimination by recipients of federal funding to consider filing a qui tam action.
So federal contractors and universities need to move carefully with respect to areas that could trigger FCA scrutiny or enforcement, including anti-Semitism and DEI programs.
Yes, that's right, Sabrina. And it appears that based on some of the recent notices of violation that we've seen with respect to universities, the current administration's focus is, as Annie said, a Title VI theory applied to DEI programs, including things like race-based admissions in universities, and second, to anti-Semitism on university campuses. So the way to think about this is that a university's failure to address anti-Semitism is a civil rights violation, and therefore it could be the basis for a False Claims Act claim. DOJ's theory could allege that a school is possibly encouraging anti-Semitism, and because it's doing so, it's not in compliance with Title VI, and it has violated its express or implied assurance of compliance upon receipt of federal funds. And this theory has been applied in recent findings against a number of high-profile universities, as has been stated in the press. Second, the administration could single out DEI practices as a violation of federal laws, and that could also trigger False Claims Act scrutiny. The Department of Education issued a letter earlier this year in which it explained its belief that federal law prohibits universities from, quote, using race in decisions pertaining to admissions, hiring, promotion, compensation, financial aid, scholarships, prizes, administrative support, discipline, housing, graduation ceremonies, and all other aspects of student, academic, and campus life. And July guidance that was issued by Attorney General Pam Bondi has warned universities about the perils that are associated with engaging in these race-based practices.
Thanks, Kamil. What steps can federal contractors take to help minimize the risk they will be subject to a DOJ investigation or an FCA action, and to navigate an investigation if needed?
That's a good way to wrap up, Sabrina. So as we've been discussing, this is clearly an area in which we expect continued focus and activity, and we can help assess potential legal risks and areas of sensitivity. So one thing is the point that Kamil made right up front, which is investing in compliance programs and making sure that robust processes are in place. If a whistleblower raises concerns internally, that needs to be appropriately investigated and addressed. A privileged review of practices and certifications that are being made and relevant public statements is also a prudent step that can be taken. And having a coordinated public relations and government relations strategy is also important.
Thanks so much, Annie and Kamil. That concludes our wrap-up episode on recent developments in whistleblowing. Thanks for listening to S&C Critical Insights. We hope you listen to our prior episodes in this series for more details on anything mentioned here today. For more information about our practice, please visit us on the web at www.sulcrom.com.